your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Alright, today I'm at Warwick Magistrates Court. Client was charged with 15 charges whilst on parole. It's a bit of a laundry list, so bear with me. There was 2 counts of disqualified driving, meaning the court had disqualified his licence and he continued driving anyway. So 2 counts of that. The problem being, though, that this was his 12th and 13th charge of disqualified driving. So yeah, 12th and 13th charge of disqualified driving. There was 2 previous within the last 3 years, so it was his 3rd and 4th in 3 years, but 12th and 13th in total. There was also a drug driving, drive whilst relevant drug present. To his credit, there was no previous drink or drug driving in his history, but that was the least of his problems, that charge. What else was there? There was 2 counts of possessed dangerous drug, one of possessing ice, one of possessing cannabis, and there was a bunch of possess utensils, scales, and that type of stuff. What else? There was one of stealing, one of possessed tainted property, and unregistered, uninsured vehicle, etc. So 15 charges in total. The more serious, there's probably 3 that were particularly serious. So the 2 times disqualified driving and the tainted property. As I said, he was on parole already for dishonesty offences. He had extensive criminal history, both drug and dishonesty offending, but it was all intertwined with he's got a drug dependency. So, a lot of the times when someone's got drug history, there's also dishonesty offences because the dishonesty offences feed the drug habit. But I mean, to his credit, though, he's got a long way to try and get on top of things. I don't want to give too much away in this video, but basically he had a difficult upbringing, developed a drug dependency as a result of that. Several years ago, cleaning himself up and climbing his way up the corporate ladder, if I could put it that way. And then when his mum died, he relapsed into drug offending, and he's basically lost everything and committed the offending that's brought him before the court today, and here we are. So yeah, 15 charges, the 2 most serious being 2 counts of disqualified driving and 1 count of possessed tainted property. Where do I start? So he's in breach of parole. That's not a matter for the court, it's a matter for parole. But it's an influencing factor on the magistrate today. Generally, when you've been given jail for previous offending, you don't get lesser of penalties if you keep offending. So jail was always going to be the outcome today. Jail doesn't always mean actually sitting in a jail cell, though. There's different ways that jail can be served, or ordered to be served, I should say. So the more serious form of imprisonment is actually going to jail. 1 step shy of that is immediate parole, which means technically you've gone into jail, but today's your first release date, and you're now on parole. But there was technical reasons why that wasn't an option today, and I'm not going to go into them now. 1 step below that is what's called an intensive correction order. So it's much the same as parole, but basically it's a hybrid between parole and probation. It's like a militarised or regimented probation, if that makes sense. So he's got to report for a period if he was to be given an intensive correction order, or an ICO as it's colloquially known. And then below that is a wholly suspended sentence, meaning you don't actually go to jail or do anything, but it hangs over your head for a period, and if you don't if you don't get sentenced for anything that's punishable by imprisonment during the period, you won't go to jail. But if you do, you can go to jail. And then below that's probation and fines, but we're well past that. As I said, if you've been given jail in the past, they don't start going backwards. They start, at worst, aggravating the penalties, and at best, not getting any worse, if that makes sense. So, even though I had my work cut out for me, my job today was to try to persuade the magistrate not to physically jail my client. He was always going to get some form of imprisonment, but as I've just outlined, there's different ways that can be served, and my job was to try to persuade the magistrate to let him to serve imprisonment by way of one of the options that don't involve him actually going to jail. This has been dragging on for a while. There was 15 charges, but I think 10 of them originated in Warwick. There was about, or maybe 8 in Warwick. There was about 5 in Southport and a few from somewhere else. So I've had to try and get charges from various jurisdictions moved into the one spot, and I moved into here simply because this is where the bulk of the charges were. So it's been a German, and just, you know, logistically getting everything in the one spot. But today it was listed for a lengthy plea. So normally when you go to court for a drink driving, whatever, it's a regular court date, and they do what's called a, you know, it's not called a regular plea, but just called a plea. But if there's lots of charges or, you know, high risk of jail, the magistrate doesn't want to deal with it on a busy normal court date, so they'll list it for a lengthy plea, and it just gives everyone the time they need to do whatever they've got to do. As far as preparing goes, I spent quite a bit of time drafting written submissions of not only case law, but his antecedents, him as a person, and what's gone on in his life, and why this keeps happening, and all the rest of it. We got him to do the Queensland Traffic Offenders Program that we get everyone to do, which is an online reformatory course that you know, educates people on road trauma and the likes. He was already getting, to his credit, psychological help, so we got him to get evidence of that, and he was also, of his own volition, getting basically going to the pharmacist or whatever it is and doing drug urine tests. So he was able to bring 3 clean drug tests to court with him. Got him to got references that we got a template we give to our clients. We get them to give to their referees so they know who to address the references to and the key points that must be addressed. We don't groom the referees, but you know, you got to make it clear that you know that this is being used for court, not for a job application. The reference, I mean. Anyway, so quite a bit of effort went into this prior to today. Drove up this morning, so I'm at Warwick, which is about a 2-hour drive west of Brisbane. Drove up this morning, met the client at court. We grabbed, I don't know if you call it a conference room. There's a little shoebox near the entrance that we use as a conference room. I ran through the procedure, my submissions, what we can expect the prosecutor to be pushing for, what I'm going to push for, you know, the various directions it could go. It was, as I said, I did detailed written submissions up, so a lot of what I wanted to say was already in writing and supplied to the court previously, and basically today was all about steering those submissions in the right direction, or keeping the matter on track with the written submissions I previously written and filed with the court. Again, the magistrate was talking about actual custody and, you know, particularly the deterrence effect, and you know, a lot of the client's history and ongoing offending. There were submissions made by the prosecutor about the imprisonment options available to the magistrate, and as I said, the magistrate did speak of actual custody. I obviously, when it was my turn to speak, was vigorous in resisting that, and, you know, pushing all the other available options that the magistrate has. I don't like to say available twice in the same sentence, but I can't think of any other words, available to him. It went for quite a while, actually, because it was listed for 9 o'clock and it's like 11:30 now, and I'm only just leaving court, so it went along longer than I realised. But I guess when you're on your feet and there's a bit of argy-bargy going on, time passes quickly. Anyway, long story short, he didn't go to jail, so he's out the front of court waiting for his ride. So he's not going to jail. What he was given was So for the tainted property, he was given the intensive correction order. So he got an 8-month intensive correction order for possessing tainted property. So basically he needs to report to probation and parole and be on a combination of, it's a hybrid between probation and parole for 8 months. So basically reporting and doing whatever testing or counselling they think he should do for 8 months. So that was for the possessed tainted property. For each of the counts of disqualified driving, he got a 6-month wholly suspended term of imprisonment. So he got the intensive correction order plus 1 term of wholly suspended imprisonment for 1 disqualified driving, plus another term of wholly suspended imprisonment for the other disqualified driving. So all of those terms of imprisonment don't involve him actually sitting in a cell. So that's the imprisonment that he got. So he's not actually going to jail, but he's got the 8-month intensive correction order and 2 different terms of 6 months imprisonment, wholly suspended for 2 years. What else did he got? He got disqualifications. So the minimum is 2 years for disqualified driving. So 2 years for each count of disqualified driving. Minimum for a relevant drug when you're disqualified is 3 months. So he got that. So 2 years, 3 months. He got fines for some of the other offences, and he was convicted and not further punished for a bunch of other offences. And convicted and not further punished is exactly what it sounds like. So you're convicted, but you're not being penalised. And the courts do that because partly it makes it administratively tidier, but also, you know, how many times you have to belt someone to learn their lesson. So they give solid penalties for the serious offences, and then I guess roll the penalty for the other ones into that penalty, if that makes sense. I'm sort of gibbering on a bit, but anyway, client's obviously very happy and relieved. You know, there was a very, very real chance of him going to jail today. He's not. He's relieved. I'm Andrew Wiseman at Warwick Magistrates Court. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I'll look forward to helping you resolve your issue today.
Don't face that court alone. Let the wise man team get you back on the road.